guys. And we're about to start this. Bear with me. This is really my first time chairing this, so, second time. He had to say that. And we shall begin.
Madam Chair, if you will please call the meeting. You've called the meeting to order, and now if we can take a pledge of allegiance.
Okay. The meeting is called to order.
Thank you.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Are you gonna swear them in?
Let's go to C and do a roll call of the board members.
Okay.
Brittany?
Ms. Philippe, Ms. Cohen,
Here.
Ms. Joseph, Ms. McGuire-Fenelon, Mr. McDermott,
Present.
Ms. Boulay,
Present.
Ms. Esteem Irvin, Ms. Hill.
Present.
We have quorum.
And we will proceed with D, which will be Mr. Nixon, the announcement to the audience of the public hearing process. Thank you.
Good evening, members of the Board of Adjustment, Planning Commission, and everybody else present. Those items are quasi-judicial items, which may either be approved, denied, or approved with conditions. When each petition is announced, the applicant shall approach the microphone and state his or her name and address for the record. Please be advised that the following items, because they are quasi-judicial in nature, if you wish to comment upon any of these items, you have to indicate your interest to address the board when the announcement regarding the quasi-judicial item is made. An opportunity for anyone to speak on each item will be made available after the applicant and city staff have made their presentations on each item. Please speak directly into the microphone and state your name and address for the record and your comments to the board. Thank you.
Madam Chair, if I may, I would like to now proceed with giving the quasi-judicial oath to any member here tonight that desire to speak on any one of these items. Anyone desiring to speak on these, if I may?
Be
Thank
my
you.
guest.
Please stand and raise your right hand. Council need not, but raise your right hand. Please swear. Do you swear or affirm that the testimony you provide is the truth, the whole truth, and nothing but the truth? Thank you. You may be seated.
Do we have any amendments to the agenda? Do we? Nope. Are we going to approve the minutes from last March 18th?
Before we proceed with the full approval, I would offer the chair and this board a slight amendment. And that amendment is appears on page 2 of 6 in the minutes. And supposedly it was a comment that I made, and it states here, this is the section that I would like to see amended, where it's the second sentence where it states that Mr. Galdo said, that's me, that at 4:15 p.m. that day, he received notice that the applicant hired a power of attorney to speak on behalf of the owner for this item. Well, while I did state on the record that a power of attorney was received by the applicant, that was a requirement because it was a quasi-judicial proceeding, and we needed a power of attorney to, so that the individual, the applicant, would have standing to present, in the absence of the property owner, would have standing to present his case. And so I would like to amend the record to indicate that we had in fact received a power of attorney. We didn't hire, or they didn't hire a power of attorney, as it is a form. And that I would like to offer you for consideration for amendment, as well as the date, as you can see below. The year shows March 18th, 2014. Of course, we're in 2015, so I would offer you that as an amendment as well, in the footnote to the left. Thank you.
Okay, I move approval of the minutes as amended.
I second it.
All in favor?
Yes.
All in favor? Okay, I'll take that as a unanimous vote to amend. Thank you, thank you.
Did any of the board members have any communications with any of the applicants? No? Okay.
You may proceed, Madam Chair, with the first item, as there are no communications by any of the board members and third parties. Thank you.
Good evening. May I proceed?
No.
Staff first.
We didn't go to directions.
I have to do directions. Okay, we're going to do the first Moises and for, bear with me with these pronunciations, Fortuna Bicachi,
Bichachi.
624-26 Northeast 124th Street will be the first we'll hear. Are you going to read?
Yes. Okay. This item was a variance to Article 4, Division 3, Section 4-303 of the LDRs, Land Development Regulations. Sorry. To allow a proposed accessory structure to an existing principal structure located at 624-26 Northeast 124th Street. To have a 2-foot setback from the side east property line where the minimum side setback is 10 feet in the C3 district, as well as a 1-foot wheel setback where the minimum wheel setback is also 10 feet in that same district. As we may recall, the members here present tonight, not all of you, this item was heard at the last Board of Adjustment hearing on March 18. And upon opening and closing the public hearing, certain residents came and spoke against the petition, and the board engaged also in further discussion and decided to table the item to give the applicant the opportunity to bring, and to work with staff and come up with some renderings and then more plans, that shows, what the proposed accessory structure will look like, and then to make sure that it's fitly, seamlessly blend into the neighborhood in which it's going to be located. And again, our staff recommendation has not changed since, because there has not been no circumstances that would have warranted that kind of change. And the staff recommendation was for approval because the application meet at least 4 of the 6 criteria noted under Article 3, Division 6, Section 3-606 of the LDR, which are necessary for an application for variance to be approved, to be granted approval by the Board of Adjustment. And those conditions are as listed. Special condition, first one, special condition and circumstances exist which are peculiar to the land, structure, or building involved, and which are not applicable to other land, structures, or buildings in the same zoning district. A second condition, the unusual circumstances or conditions necessitating the variance requests are present in the neighborhood and are not unique to the property. Third, that the requested variance maintains the basic intent and purpose of the subject regulation, particularly as it affects the stability and appearance of the neighborhood. Fourth, the literal interpretation of the provision of these LDRs would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the term of these LDRs. Fifth, the variance requested is the minimum variance that will make possible the reasonable use of the land, structure, or building. And sixth, the granting of the variance will be in harmony with the general intent and purpose of these LDRs, and such variance will not be injurious to the area involved. As you can see in the report, in front of you, the application has met, at least 4 of the 6 criteria, because the first one, the subject property is an undersized, irregularly shaped lot, which was created, prior to 1958 when the city adopted its first zoning code. And half of the rear of the property has been carved out, not only leaving the existing office building with seemingly no setback from almost half of the rear lot line, but also making it impossible to build the accessory structure. And secondly, the parcels in the block in which the subject property is located were also created before 1958, which justify, the fact that, if any other those properties want to put an accessory structure, they would have to apply for variances because those lots were created prior to the inception of the code, and then at that time there was no regulation as far as subdivision and setbacks or such other dimensional requirements. The variance also maintains the basic intent and purpose of the LDR. Because the proposed structure will be located in the rear of the building and will not be located will not be visible from any public street, even though there's an alley in the back, but it's not a really heavily trafficked street, and then it's going to be buffered from other surrounding streets by other commercial properties. And then the applicant has since submitted, new elevation plans and renderings that show or seemingly, and arguably, a very decent looking building that will not really be injurious really to the area. It will seamlessly blend into the context, its context. The variance is really the minimum that will be make possible the reasonable use of the land. The applicant, what he's trying to build is about 600 square foot building in the rear subject, and as stated in the letter of intent, it's to allow for additional storage area for that office use building, which was built around about 70 years ago. So they have outgrown the space, and then they wanted to provide, more storage area. And then finally, the variance will be in harmony, and again, the new plans that the applicant has submitted, really show a major improvement from the last plan that they submitted before, and then with further, a board input and recommendation, they can even make it even look better. So we figure that this variance application is really consistent with the requirements of the LDR, and then is consistent with the comprehensive plan. So as such, staff has recommended approval for the item.
Any comments? Oh, comments from the public, please?
Public hearing. Applicant.
Good evening, Madam Chairman, members of the board and staff. My name is Frank Woland, and I represent the Bicacci family. This is the Bicacci family. Fortuna Bicacci, Moises Bicacci, and Eli Bicacci. And this is a family-run business that they run. They have a construction business, which is actually fairly unique in North Miami. They are contractors, but they happen to also be defense contractors. So their business, which they moved to North Miami about 8 years ago, does work for the Department of Defense. They're building the Key West Naval Air Station Joint Interagency Task Force building now as we speak, the gun range for the Coast Guard on Miami Beach. And they're also, minority low-income housing contractors for HUD. They have a wide range of work that they do for a small family business. They were previously located in North Miami Beach. The property, and I have a set of before and after pictures that I'd like to pass up to the board. If I could. The property was purchased by them in 2008 when it was in foreclosure, and it was abandoned. They rehabbed the property. They put on a new roof, new plumbing, a whole new floor. They added a sidewalk. They made it handicapped accessible. They spent in excess of $400,000 to make this property what I think is one of the nicer properties in this particular little business area of North Miami. They also received a beautification grant from the CRA of $85,000, which, as you can see, they have put to good use. This is a family business. It employs 13 people. They are pretty much at the limit of their capacity, and they have grown as much as they can grow. And they need the storage. They need to be able to utilize this property at the very back of their property for storage. For example, the doors for the Naval Air Secure Facility, they're special doors. They have to store them. They've shipped them from Ohio. They need a place to keep them until the building's ready. It's not unique. It's a situation that they have every day. So they need this to grow and expand their business and really to keep their business successful. It's not a very big building. It's entirely contained in their property. Instead of a 10-foot setback on the side, we're asking the board to approve a 2-foot setback. And that's the side. Right here. And that's the east side. East side faces a building. The only, windows in that building are these tiny little windows that take in light. They're not going to disturb anyone's view. They're going to maximize their use of the lot. Their building is pretty much consistent, and as you can see from the picture, they've really done a nice job of making this a nice-looking building. And as I say, if you view the building from the alley, their structure is one of the nicer structures, which shows a certain pride of ownership, which they have maintained. The back of their lot permits them to build a storage structure like this. If they were to build a structure and not secure a variance, it would look something like this. In other words, there would be the setback on each side of the structure, and it would be right in the middle. This is an irregularly shaped lot, and that's why they come within the criteria of having a hardship so that they could get a variance. They would then have to park one or two cars here, one or two cars here, and it really wouldn't work. I mean, they could do that, but then how would they get access to the building? The building, the way they've proposed it, gives them landscaping. It maximizes the access.
Mr. Wolin, I'm sorry, Mr. Wolin, on the record, please. Thank you.
It maximizes the access. It allows them to park a couple of cars in front, which they can back up behind each other, and it makes their property usable. We're asking you, please, to follow staff's recommendation. I have some more renderings, but they're pretty much what you see. We're happy to answer any questions that you might have. Thank you.
Let the record reflect that 2 photographs were given to this board by the applicant. Thank you for your consideration. Thank you.
Is there anyone that wants to speak against this at this time? For or against? We're going to close the hearing. Okay. Do you want discussion?
Yeah.
Go ahead.
Yeah. Yes, in looking at this, I understand what they're trying to do, and I think it makes a lot of sense. And they're not really doing much. They're not really doing anything within, that really extends into other people's properties. They're just asking for setbacks that allow them to accomplish really locating the building that makes their original property more usable. So it just so to me, it looks like that they're simply trying to enhance their property within their boundaries that already exist. So I don't see why we would want to hold that up at all.
I have a question.
Sure.
You had just said that they could build that variation without any type of variance?
They could build a structure, but it would not make a lot of sense.
No,
In
I
other words,
understand that,
yeah.
but they wouldn't need a variance in order to do that?
To do that, they would not need a variance. In other words,
Is that true?
The variance that they're seeking is for a setback.
I understand that,
base-
but if they were to build that additional piece of the second,
No, if they were to build this right now, they would just have to apply for a building permit.
a
As it
building
means
permit.
as it means the setback.
It
That
would
not
be
come
as of right.
as of right.
As a
yes.
right
Right.
to
But
build
they
it.
would not
Okay.
have the parking, and it really wouldn't make sense or be as nice as what they have. They wouldn't have the access.
And so the building that this is going to butt against and the windows that are going to be enclosed, does that belong to them as well?
No, they're not abutting it. There's a 2-foot space, and that is a neighbor's building. That neighbor does not object to the building that they're building.
I have a question. It looks like at the last meeting, one of the issues that was of concern was parking. You say there's
Yeah, that's
13
what's gross.
employees at the business currently.
No, I said the business employs 13 people.
Mhm.
So it's a construction business. Most of the time, the people in the business are
Out
2 or
of the
3
way.
people.
Oh, okay. And how
And
many
the other
parking
people are out
spaces?
working.
How many parking spaces do you have allocated already?
As it is we have about 4 spaces that are usable, 3. But if you park behind someone who you know is going to be there all day, maybe a
And-
little more,
And that fits on the property?
yes, within their gate. And frankly, that's pretty much what they'd have afterwards.
Yeah.
It's not
Yeah.
hurting the parking.
Can I
And
have
they-
a follow-up question?
Yeah, and they
then?
also have on-street parking as well in
That's-
front of the building.
That's 2-hour
is
parking,
accessible.
correct?
Hmm?
Yes, it's
That's
2 hours.
2-hour parking, which isn't really
Yes.
designed for.
A follow-up question, if there's only 3 now, how is it that you're going to have those 2 extra ones once you put that structure in? It seems to me you have 5 now, because you have the 2 that you're going to have available to you when you build that structure. So if I'm counting right, you have 3 against the wall, and you have 2 on the other side, so that's 5 now.
When you say against the wall, the way it presently works,
Mhm.
there are probably 5 cars that you
Okay,
could park by
okay,
parking
then,
behind them.
all
You're
right.
correct.
So
And
there
you
is
would be
5.
able to park by parking behind 4 if you give them the variance. 2 and 2. 2 in front and 2 in the back.
If I may add, one of the reasons why we didn't, consider, having them apply for parking variances based on the size of the building, it is because, they are exempt from providing parking on site, given the location of the property, close to the municipal parking lot. I mean, there's a provision in the code that allows, because of those lots, they're so old and they were so small, that allow, especially in the downtown, for businesses not to provide on-site parking if they were located within 200 feet of a municipal parking. Also.
Okay.
Madam Chairman? Oh, I'm sorry. Go ahead.
Madam-
My only concern would have been, as we all stated, the parking, but you've explained it, so I don't
Thank you
see
very much.
any, I don't foresee any issues with it. Also, this is, the first picture, is that the picture of the front of the building and this is the rear? Or what exactly in, of course. So is this the front? and
This is the
rear?
front, and that's the rear, yes.
And then this is where the structure will be.
Right here.
Okay, and
In
this is
front
what
of
it'll look
that.
like. Okay.
Thank you.
Can, for the record, and for all those that are viewing, can you please turn that photograph around and explain, indicate what Mr. Wolin just indicated to you?
I feel like Vanna
One
White.
is the top
The
photo
top is,
is
the top is the part facing the street,
Thank
in
you.
other words, facing north. The middle photograph is the back of the property, which faces south. And then the bottom photograph is the rendering of the storage building that we plan to build.
Thank you.
And they can enter from this part of the building as well as the other end of the building as well?
Yes, they
Okay.
can.
Okay, Madam Chairman?
Does anyone ready to take a vote on this?
Yeah,
Yes.
Madam Chairman, I'd like to move approval of the item.
I'll second.
You have to say yes or no.
Yes.
No.
Well, can we do it under a roll call?
Okay.
Roll call.
Roll call.
Thank you.
Ms. Cohen,
No.
Mr. McDermott,
Yes.
Ms. Boulay,
Yes.
and Ms. Hill.
Yes.
Thank you.
Thank you very much. Have a nice evening.
Thank you.
Thank
Take
you.
care.
Motion passed.
Okay.
The
We're
item
gonna-
passes 3-1. Thank you.
Okay, we're moving on to the next V415, T-Mobile South LLC Special Exception, use permit for a wireless antenna replacement at 12635 Northwest Fifth Avenue.
Again, good evening. This application is for special exception use pursuant to section 29A-8 of the North Miami Code of Ordinances to permit or propose concealed wireless antenna canister attachment to a proposed replacement FPL transmission pole at the North Biscayne substation located at 12635 Northeast Fifth Avenue, which does not meet the minimum setback requirements set forth in section 29A-5J. This application came to us, because T-Mobile is trying to extend, improve their service area within the city, and then the code, has a provision to allow them to do so for a antenna. They could have gone straight to a building permit upon, meeting, the requirements, but as it stands, even though the proposed replacement will not meet the fall zone or the setback requirement specified in Chapter 29. Even though it should have been a variance, I don't want the board to be kind of confused by that. But the way the code is written right now, if it doesn't meet those criteria, it is a special exception use instead of a variance. So I just wanted to point that out first. So what they're trying to do, they're proposing to replace an existing 70-foot tall transmission pole with a hardened 78-pole structure with a 12-foot canister containing concealed T-Mobile wireless antennas attached for an overall pole structure height of 90 feet. The replacement pole, which will be in essentially the same location, approximately 5 feet south of the existing pole, will serve the same dual purpose of supporting FPNL transmission lines as well as the concealed wireless antennas. Section 29A-5J requires a setback of 110% of the pole height from each property line. In this case, since the proposed pole is 90, the 110%, which is the radius of the fall zone, should be 99 feet. However, what they're proposing is because of an other constraint on the site, they're proposing a 48 feet setback for the replacement pole. As such, they have applied for that special exception use permit. And again, staff has reviewed this application under the criteria of section 29A-8, and in section 29A-8D of the city, and also Article 3, Division 5, Section 3-504 of the city LDR. So, I mean, again, in the report, you'll see, how, this application complies with or meeting the standards, set forth in those criteria for review of special exception use for antennas, and without, being, too long on that subject, on staff, we have made a recommendation for approval as it meets most of the criteria, and then this is or use actually that would be a public service use to improve, a service area in the community, but we have imposed certain condition on the item, and then the condition is that the construction is subject to the licensing authority of the Federal Communication Commission, FCC, and an application for construction permit must be filed as required by the FCC within 6 months of the date of the determination by the FCC, pursuant to the aeronautical study of the Federal Aviation Authority. The second condition is that the antenna must meet or exceed current standards and regulation of the FAA, the CC, including emission standards in any other agency of the local, state, or federal government with the authority to regulate towers and antennas prior to the issuance of a building permit, and that a certificate of use from the CPND be only issued upon compliance with all terms and conditions of this approval, the same subject to the cancellation upon violation of any of the conditions listed. And again, that the applicant shall comply with all applicable division of Chapter 29-A as it relates to a security fund and other penalty clause if they fail to meet those requirements. And then again, staff recommendation is for approval. Thank you.
Thank you. Does anyone want to speak on behalf of this
On the applicant.
applicant?
Good evening, Madam Chair, board members. My name is Deborah Martyhue, 9150 Blind Pass Road, St. Pete Beach, Florida. I represent T-Mobile, the applicant, and I'm here with Kifle Amha, who's our RF engineer expert. He's here. Bob Bolu. I'm having some names tonight too, and I have a difficult last name. He's the FP&L representative, and Amy O'Rourke is here on behalf of T-Mobile. First of all, I want to thank Nixon LeBron. He's been a pleasure to work with throughout this process, advising us as to, that it was a special exception and not a variance. We appreciate all of his work on this, this case. We are asking for a special exception. We concur with staff's recommendation and analysis completely. We have no issues or concerns. The reason that I want to keep this short because I know you have a long agenda and we're here for questions. The main primary reason that we need this, it's not a setback variance, but the reason we're in here is a special exception is because the FPL pole itself, it's actually a dual purpose. It serves the transmission as a transmission pole function, as well as then attaching the canisters with the antenna. The constraint, we could shift that pole from a radio frequency standpoint to meet the setback, but what we couldn't do, we couldn't shift the pole from a construction standpoint for FPL. They have their engineers analyze, and it's something about the angle of how the transmission lines connect between poles. They're physically, and that's all in the staff report in our application, they're physically constrained to a certain angle that would not allow us to shift the pole more westward. So currently the pole is 48 feet from the east boundary. We're sticking with 48 feet from the east boundary. We're just moving 5 feet to the south. The pole itself is only 15% taller. This particular transmission substation facility has been in existence for about 63 years. You can see from the photo simulations, I believe, were attached to the report and given to you that the replacement pole itself does not change the character of the substation that the neighborhood grew up around, and this is what the facility has always looked like, and this doesn't substantially change the character of that facility. So we're asking for your approval, and we meet all of the special exception criteria. If you want me to walk you through it, I can, but I know it's in your staff report. He just checked off every box, Mr. LeBron did. He did an excellent job. And we request your approval. I'm here to answer any questions. Mr. Amha is here to answer any questions in terms of need. We provided the propagation maps that show our need before and after. And I just reserve time for rebuttal if there are any people in opposition. I've been checking with Mr. LeBron this, entire week to see if anybody's called or written. And as of this afternoon on my drive over, there were no calls or letters, but Mr. LeBron can confirm that. I don't know if anybody's here tonight. So we're here to answer any questions, but it really is more of a physical constraint by FP&L than it is whether or not, from a radio frequency standpoint, could we shift it? So we're kind of locked into that spot. Does that make sense?
Mhm.
Is that right? Okay. So we're here to ask, to answer any questions.
Does anyone else want to speak for or against this variance request? Does anyone have questions?
Yes, to me, the photograph,
As a point of order, I
On-
apologize,
I'm
Madam Chair, I
sorry.
apologize, Mr. McDermott. You have opened
Mhm.
and then closed the public hearing, the public commentary? I
Well,
just
no
want
one
to
else
verify.
wants to speak.
Anybody? Okay.
just
I
close.
just want to make sure that it's been
Yes,
closed,
it's
and then we
closed.
can proceed with the
Okay.
questions. Thank
Okay,
you.
sorry.
Okay.
Go ahead, ask your
Okay.
question.
Yeah, on the photographs that we have on PS4, shows the relationship between the two existing poles and new pole. Doesn't seem much of a distance. But here's my question. The FP&L, maybe it's more directed to the gentleman from FP&L. Is that pole still going to be used by FP&L?
I can answer, and FPNL can confirm, but yes, it's a replacement pole. The other one will be, Mr. Bull, you want to, for the record, he should probably confirm that.
Good evening, Madam Chair and board members. For the record, Bob Bulliu, Project Manager for Florida Power and Light. And yes, that structure will be used. It'll have two uses. One, to support the conductor from the transmission line to the station, as well as for the telecommunications equipment.
Okay, so it's basically a support of the new pole.
The pole's replaced, so there'll be a new pole, 5 feet. There's a differential of 5 feet. It'll have a dual purpose to support our transmission line into the station, as well as the telecommunication equipment.
Okay.
Okay.
I have a question. What is the general lifespan of a pole?
Well, now they're spun concrete and different materials. Decades.
Okay.
I can't speak exactly to it, but it's a very, very long time, and we're in the process of hardening right now. So we're improving our infrastructure.
Okay.
Question.
Can you just, go ahead.
On sheet number, PS2, what is the proposed T-Mobile compound? What is a compound?
You're taller than me. The compound is 15 feet by 15 feet. That actually houses what they call ground equipment. They're
Okay.
cabinets that relay the electronic equipment up to the antennas and have conduits and cables, but they're in a secure compound, locked, so it has to be secured. If I could just follow up on that, the question about hardening the structure and the lifespan. It was in the application that one of the reasons FPL is replacing some of these poles throughout their substations is to bring them up to code, harden them, make them more up to code for hurricane purposes, and also it's a reliability issue for their own utility service to the neighboring community. So, like I said, what's happening is the wireless industry is trying to partner with the utility industry to help serve that dual purpose where they have to harden their structures anyways, and we need to provide service to residential communities. And this is one way we can create a win-win and do that without proliferating just additional towers, additional monopoles out there with antennas on them. This is concealed antennas as well, so they're camouflaged. Okay?
I have one question.
Sure.
Actually, two, and just trying to clarify it. So, in essence, you're putting up a new pole, and then you're taking down an existing pole and putting it back up, or you're going to have only one pole?
Only one pole,
Only-
the existing pole comes
Okay.
down.
I guess my second question is this an unusually tall pole being put in this particular area because you had to get license from or a statement from navigation? So is this particularly tall?
No, we do determinations of no hazard from the FAA in every case. That's just a standard operating procedure. Because you have a lot of airports around here, particularly private. Yeah,
Opa-locka.
down in Miami-Dade, we have to also not only do the FAA determination of no hazard, but we have to go through Miami-Dade County Aviation and make application as well. So it's standard operating procedure.
Okay,
I'm-
but this, my real question is the height.
Right.
I'm trying to find out if you picked this area to be one of the highest poles in the neighborhood because you can.
No,
And
not,
that's what I'm trying to find
no,
out.
90 feet is actually on the lower end of poles that I ever put up. I've put
Okay.
up poles as tall as over 550 feet in Collier County.
Okay, all right, I'm just checking.
Yeah, no, and no, that's a good question, because as you can see, FPL's existing pole is 70 feet. Their replacement pole, regardless of what we needed to do, was gonna be 78 feet because of their needs. Then we have a 12-foot canister, and you need that spacing for the antennas. That's just, they call rad centers, and you have to attach the antennas, you need 12 feet. And so it's really only a 15% increase over what they would already do anyways. And it's better to co-locate than to just go and build another tower somewhere in the neighborhood. Okay.
You answered my question, thank you.
I have a follow-up question to the question about the compound.
Yes.
So was there a compound or is there a compound for FPNL that already exists and T-Mobile's just swapping over onto that compound, or is this something that you'll be building onto the structure?
Yeah, go ahead.
For the record, Bob Beaulieu, typically in our substations, we have a structure, it's an electrical vault, it's an actual, four-sided building, with a roof. It's fairly large, approximately, 15 by 40 feet. That's within the compound of the electrical substation. That's totally separate from what T-Mobile's doing here.
Okay. Okay, the reason why I asked is because this is actually in walking distance of my home,
Okay.
and there are a lot of children in this area, and I can even remember as a kid attempting to go into that area out of curiosity to see what was there and to see, if we threw a rock at it, if it would blow up or some craziness. I can remember us doing, silly things like that. Directly behind that structure, that proposed structure, less than maybe a block or not even a house or so away, there's a church with a Christian school. I think it's it's right there. So, that's my concern, is just making sure that it's a safe enough structure so that kids that were like me, don't get hurt and that kind of thing.
They're secure. They're 8-foot chain links, gated, secured, locked.
Okay.
Typically have barbed wire on top, landscaping around it. Because trust me when I tell you that they don't want little kids breaking their very expensive equipment either, and it's pretty secure. And it's pretty typical to have the compounds on the ground. The only time we have equipment on a building, usually on a rooftop, is when we have what we call roof-mounted antennas. But when you have a pole structure, the equipment is right on the ground. It's in close proximity to the pole because they've got to run coax cables and various electrical conduits to the pole. So it's got to be proximate to the pole. And they secure the pole as well inside the compound.
Yeah,
Gotcha.
Okay.
Thank you.
okay.
What-
Madam Chairman? Oh, I'm
I
sorry,
have
Laura.
just a quick question. How long is this process take to take down the old pole and replace it with the new pole?
120 days, roughly.
On the record, please. On the record.
They'll have to go through building permit, so Mr. LeBron could probably address that a little bit better, but typically that's about a 30-day process, building permit. And then a construction, in my experience,
I mean, the actual replacement of the pole happens in a day.
Right,
I mean,
that's
they
what I
pull
was
it out and put
wondering.
it in. It's very quick, but,
Okay.
leading up to it, there's time.
Okay, thank you.
Okay, Madam Chairman?
Does anyone make a motion?
Move to approve?
I second.
I'll second it.
Oh.
Roll call.
Ms. Cohen,
Approved.
Mr. McDermott,
Yes?
Ms. Boulay,
Approved.
Ms. Hill.
Approved.
Okay, congratulations.
Yes, congratulations.
Thank you.
All right.
Consider good tonight.
We're up to V-5-15, Robert Christopher Benyo, setback variance for proposed enclosed garage addition at 13255 Biscayne Bay Terrace. Is anyone here that want to speak on behalf of the applicant?
Hi, Madam
It's
Chair.
your turn. I'm sorry, it's his turn.
Oh, I was wondering, okay, that's what I thought, okay.
I'm just moving
Yes.
quick.
This item is for variance to Article 4, Division 2, Section 4-203 of the North Miami Code of Ordinances, Land Development Regulations, to allow a proposed enclosed garage addition to an existing single-family residence in the R1 zoning district to set back 6.2 feet from the interior side, which is on the south property line, instead of the required minimum side setback of 10% of the width of the lot. In this case, 8 foot for the subject lot, as set forth in the land development regulations for developments permitted in the R1 zoning district. As a background, the subject property, comprises, 10,000 square feet. It's a waterfront property located on the east side of Biscayne Bay Terrace. It has already been developed with a 2-story, 5,000 square foot single-family building, which now has 5 bedrooms, 4.5 bathrooms, a family room and entertainment room. The applicant is seeking to expand the building envelope to accommodate a third car in the enclosed garage and to increase the entertainment room located behind the garage on the ground floor. He also proposed to include the addition of a small office study room next to the master bedroom on the second floor. This item was reviewed under the criteria of Article 3, Division 6, Section Section 3-606 of the city's land development regulations. Again, the application needs to meet to comply to 4 of the 6 items as I'm about to list. The first one, special condition and circumstances exist which are peculiar to the land, structure, or building involved and which are not applicable to other land in the same zoning district. 2, there are unusual circumstances, necessitating the variance request, which are present in the neighborhood and are not unique to the property. 3rd, the requested variance maintain the basic intent and purpose of the code. 4th, literal interpretation of the provision would deprive the applicant of rights commonly enjoyed by other property owners in the same zoning district. 5, the variance is requested is a minimum variance that will make possible the reasonable use of the land. And 6, the granting of the variance will be in harmony with the intent and purpose of the LDR. Upon evaluating this item, or the applicant's request, the first criteria is met. The residential structure on the property was built in 2002 and provided a setback of 15.2 feet on the south side, which is almost twice the minimum required setback on that side. The garage door will have an opening of 766 feet, which with the addition of the required 16-inch column will reduce the setback on the side where the expansion is to be built to 6.2 feet. I mean, let me also mention, this application, what requires to get an administrative variance is only a 20%, decrease of the setback. In that case, the applicant provide from 8 to 20 feet from 8. It would have been about 6.6 feet, 6.5. So that would have been approved administratively. But because it's less than that, then that's what they require, a full Board of Adjustment approval. And this is really a minimal variance when you compare, to what can be approved administratively. And then, therefore, it's because, of the third door, and then the column, the size of the column that needs to accommodate, the expansion, that's what necessitates, that variance. That variance does also maintain the basic intent of the code. I mean, this improvement, no, we doesn't only, improve add to the value of that house, but also to the neighborhood as a whole, because it is an improvement, that would increase the tax base, of that property, and then, as a matter of fact, the surrounding property. So it will not be injurious to the area, that will maintain the basic intent of the code. I mean, as far as the literal interpretation would deprive the applicants, we have determined that this criteria was not applicable. And as well as, is it the minimum variance, to make the reasonable use of the land, because no, it also not applicable. But again, in summary, the variance request is to allow the applicant to expand his property to accommodate a third car garage. It does not change the use of the property as a single-family residence, and will be in harmony with the general appearance and character of the neighborhood. And then, as a result, staff has made a recommendation for approval of this item. Thank you.
Now, if you want to say something.
Hi, Madam Chair and board members. My name is Jamie Coco, and I represent Mr. Benyo, the homeowner. As Mr. Nixon so nicely detailed, we are in absolute agreement with his interpretation and his recommendation. This is a very, as you detailed, it's a very minimal variance that's being asked here. It's consistent with prior LDRs, and it does not have any impact on the neighborhood. Excuse me. In fact, Mr. Benyo can explain that we received all the cul-de-sacs neighbors, excuse me, approval, and we have them signed off on it as well. Primarily, the reason for the variance is to accommodate the residential cars. There has been some recent break-ins in the past. There were some safety issues, as well as his home does house a large family. Other than that, I don't want to waste much of your time, but if you have any questions specifically regarding the project itself, Mr. Benyo is very, very knowledgeable of them, and he would be happy to answer any questions that you have.
Does anyone else want to speak for or against this application? Then I guess we'll close. I'm getting there. Thank you. Anyone want to have a question?
You mentioned something about safety issues. What happened?
Yes, sir.
Good afternoon, Madam Chair and board members. Robert Benyo, 13255 Biscayne Bay Terrace, North Miami, Florida. There's been quite a few break-ins, house break-ins in the neighborhood. My neighbor's car was stolen out of his driveway just a few months ago, and it's a concern. My car was broken into, I think, 2 years ago. So crime is definitely a concern of ours. My family is growing. I'm living in a house of women besides myself, and my teenage daughter's going to start driving soon, and I'd like them to be able to pull into the garage, close that garage door behind them, and then enter the house. And I'd like the cars not to be broken into, so locking them in the garage would definitely help us out.
You said you got the permission of the other residents on the cul-de-sac. Did
That's
you bring
correct.
that with you?
Yes, we do. My architect has it. The immediate neighbor, if you want to speak about the immediate neighbor, is probably the biggest concern. We sat down with her. We explained we're only going to come over 20 inches of what I could easily get a permit for, but it just doesn't make sense to build a garage that's 6 feet wide. You can't get a car in there. So we discussed it with her. We talked about a retaining wall. My house was built in 2002. Her house, I think, was originally built in the 50s or 60s, one of the first houses built in the neighborhood. So the retaining wall was a concern of hers. So we have discussed putting a retaining wall the full length of the property, and then, of course, enhancing it with, beautification of shrubs and trees and whatever she really picks out, I'm willing to do for her. And that was her only concern, was that, and that we're not going to be adding any windows. So we're not going to be looking at her and her husband having dinner.
And she was fine with that and
She was
signed off
fine with
on
that.
it?
She signed off with it. All the neighbors on the street signed off that are adjacent to us, and even in the cul-de-sac. There's 2 neighbors that we couldn't get a hold of. One guy's out of his house. His house is under construction right now, being renovated, and there was another neighbor, I think, on vacation.
Does this image consist of the retaining wall? That's this one, right?
There's a partial retaining wall there now that's on the neighbor's property, and what we plan to do is replace that retaining wall and put the retaining wall on my property.
I'm so sorry, I didn't hear the last part of what you said.
If you see, there is an existing retaining wall that goes, I think, 15 or 20 feet into the property line. That's the neighbor's retaining wall.
Uh-huh,
That's actually 9 inches over on her property line. So
okay.
what I proposed was to make a retaining wall the full length of the property, and then she can take that wall down, so it's not a kind of a zigzag back and forth between the property lines.
Okay.
Any further questions?
As a point of order, the property was posted and there was a mailing to adjacent property owners within 500 feet radius, and there were no negative comments received.
Okay. Great.
Let the record reflect that a site plan has just been forwarded to this board for its for its consideration, containing signatures of approval by adjacent
Yes, I see
property
them.
owners. I just wanted to put that on the record. Thank
Okay.
you.
Yeah, the
Thank you.
mailing, the 500-foot mailing is standard procedure, isn't it? For all the,
Yes, it
it's
is.
standard that they send out 500
Mhm.
feet.
Yes, it is. But since we were asking, whether it was approved, I just wanted to also offer the other side of the coin, which was we received no negative comment on that. Obviously, if we did, that would be submitted as part of the record. Thank you.
Okay.
Madam
Anyone
Chairman?
want to make a motion?
Yes, I'd like to move approval.
I'll
second. Okay, you want roll call?
Ms. Cohen,
Yes.
Mr. McDermott,
Yes?
Ms. Boulay,
Yes.
Ms. Hill.
Yes.
Congratulations.
Thank you so much.
Congratulations.
Thank you, appreciate everything.
Okay. Approved. Okay. Here you go. Got all choked up, huh?
Take care.
Well,
Congratulations.
And good luck.
all right, we're up to V615. Michael Shearer, setback variance for an existing dock, 2032-2040, northeast 121st Road. Please.
This is a variance to Article 4, Division 2, Section 4-203, and Article 5, Division 6, Section 5-601D of the North Miami Code of Ordinances, Land Development Regulations, to waive the 7.5 side setback requirements for an existing dock in connection with a single-family residence now demolished with a physical address of 2032-2040 Northeast 121st Road, which was built on a platted double lot that is now being divided into 2 separate single-family lots. The subject, 18,750 square foot waterfront platted double lots 16, 162, and 163 of Sanssouci Estates Plat Book 50, page 86, was previously developed as one single-family residence. The applicant purchased the properties in 2014 with the intention of redeveloping them into 2 new single-family homes. The old structure has since been demolished, and plans to build a 2-story home on each lot are currently being reviewed by the city's Building and Minimum Housing Department. The previous development on the properties feature a 40-foot-long dock that straddles the adjoining line of the 2 lots. The subject dock, which is relatively new, was built in accordance with the City of North Miami Code of Ordinance and all applicable Florida State and Miami-Dade County laws, especially as they relate to the protection, conservation, development, and utilization of the natural and developed resources within the Biscayne Bay management area. So, because the property is being split into 2, therefore, the existing dock doesn't meet that setback, because there has to be a 7.5 feet setback, because between the property line and the dock. But right now, the dock straddles over both property lines. Since the property is being rebuilt, the applicant has applied for a waiver of that setback requirements to keep that existing dock, even though the property is being split in 2. So and then that is applying for a side setback a variance or waiver of that variance. And then we have reviewed this application under the criteria set forth in the code also. And then I think I've listed them, in the previous application. I don't want to bore you with those the reading of those items again. And I'm just going to go and see how this application, this particular application meets the standards, those criteria. The first one, as it relates to whether or not special condition and circumstance exist, which are peculiar to the land structure or building involved. The double-platted lots have separated folio numbers, and 2 units of title were allowed to be developed as a single-family residence with the structures, pool, and dock straddling the 2 lot lines. The applicant has recently purchased the properties, demolished the main house, and appurtenant structures on same, at the exception of the dock, and applied for building permit to construct 2 new independent single-family homes on each lot. The dock was built in recent years, meeting all the standards and requirements of the state, county, and city reviewing agencies. Since the 2 lots were united, the dock was allowed to straddle the lot lines, as no setback was required. Now that the lots have been separated, the dock has become non-conforming, and in order for the applicant to extend it on either side while still staying within the required setbacks, this variance is necessary. This situation creates, therefore, special conditions and circumstances which are peculiar to the proposed dock, which may not be necessarily applicable to other structures or residences in the same zoning district. Are the unusual circumstances necessitating the variance request present in the neighborhood, and are they not unique to the property? This staff has made the determination that this criteria is not applicable. Third, does the requested variance maintain the basic intent and purpose of the subject regulations, particularly as it affects the stability and appearance of the neighborhood? The requested variance is to keep an existing dock that straddles over 2 lots. Said dock has been an integral feature of the previous development that was built on the 2 lots, and if it is to remain, will not have any negative impact on the aesthetic quality of the bay and surrounding residents. Therefore, staff believes that the variance maintains the basic intent and purpose of the LDRs. Does the literal interpretation of the provision of the code would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district? Staff has made a determination that this criteria is not applicable. This standard is not applicable. Fourth criteria, is the variance requested the minimum variance that will make possible the reasonable use of the land, structure, or building? The requested variance is warranted and is indeed the minimum variance that will make possible the reasonable use of this existing dock by the future owners of the 2 new single-family homes undergoing building permit reviews at the city. No other variance is being sought for this dock, or for that matter, the proposed new single-family. And as the proposed extension will far exceed the minimum setback from the adjacent owner's property line on either side of the 2 lots. If you look at the plans, the setback being proposed on the other 2 sides is 15 feet. And then the applicant at first had wanted to apply, for variance on that side also. And then upon sitting down with him, we have made the determination that it would be best, since not to have a humongous structure in the back or dock, and to have more than enough setback on the 2 adjacent, sides. Will the granting of the variance be in harmony with the intent and purpose of the code? The variance request will allow the continued use and maintenance of an existing dock, which is to be shared by the future owners of the single-family homes being built on the 2 separated lots. The request neither will change the use of the property as a single family, nor will it allow the existing dock to be maintained or altered in a manner that increase the extent to which said structure is in violation of any existing requirement, such as its projection into the waterway or above the seawall, and particularly the setback requirements from which this variance is being sought. The dock has been an integral feature of the previous development that was built on the 2 lots, and if it is to remain, will not have any negative impact on the aesthetic quality of the bay and surrounding residents. It will be in harmony with the general appearance and character of the bay area around the property, and will not result in the diminution of the value of any adjacent property. And based on the foregoing, staff has made a recommendation for approval of this variance request. Thank you.
Does the applicant wish to come and speak on his behalf?
Good evening. My name is Mike Scher. I live at 2310 Bayview Lane, North Miami. I have no specific comments beyond what Mr. LeBrun has identified. I'm here to answer any questions.
Does anyone else wish to speak for or against this application? Then I say it's closed. Does anyone have any questions?
I do actually have a question. On page, let's see. On page 5, it says, now that the lots have been separated, the dock has become non-conforming, and in order for the applicant to extend it on either side while still staying within the required setbacks, this variance is necessary. It's kind of a technical question. Will this variance bring the dock back into conforming status?
Yeah, because what happened, as in separating those two lots, because the lot straddles, the lot lines, then therefore a setback is required. A setback of 7.5 feet is required.
Between
Yeah.
the-
If you look
between
at
the
this
property.
diagram,
Yeah.
the survey, you'll see different a color key showing the property line. When this property was divided now into two properties, the existing dock would remain in the middle of both properties.
Right.
So therefore, it's in violation because there's no setback between the newly formed boundary separating the two lots.
Right.
And that's the variance that's being sought after.
Okay.
In separating, it created the violation in separating
Right.
the lots.
Okay.
We get it.
Thank you.
Any other questions? My only question is, do the two people that are going to buy these homes know each other and like each other? Are you creating a
As part of
feud?
as part of the sales condition, it will be identified that the dock have a shared border. And at that point, if they don't like each other, they can always put a barrier between them. But
Okay. Being
And that would be
facetious.
recorded.
I think, as a point of order, I would, if consideration is for approval, I would also like to condition this consideration based on the fact that I'm not sure if you have gone before the Shoreline Committee, Miami-Dade County, or if you have to, or if you even have to go through Durham for approval, but which I'm sure you do. And I would like this board to be aware of that, and that if you do move to approve, that these two agencies, which literally preempt us, are considered, and that approval of those two agencies, if and when required, is first complied with prior to
So,
this variance being approved, fully approved.
yeah, so council, the motion would be to approve the application depending upon the acceptance, application and acceptance by Durham.
Exactly.
And the
And the Miami-Dade County Shoreline Review Committee,
Shoreline Review Committee.
if necessary, I'm not sure, I
Well, I
represent
know
you.
they have to do Durham, I know that.
For certain. They're very close to the bay, but they're sort of like on a canal, so I'm not sure if the review committee has jurisdiction, but I don't work for the applicant, so I'm not gonna go.
Do you remember last year, we had this very issue with the Shoreline Committee? Remember with that?
Yes,
Remember
yes.
with that?
Yes.
And so you're probably gonna have to deal with them, because we went through this very thing
Yes.
in the same location.
Yes.
Remember that?
Yes,
LeBron?
and they have the power
Something
to
like that,
actually
yeah.
file an injunction against the city to prevent any building permits. So,
Right.
I want to
Right.
put that out there so that you condition, if you're moving to approve, you condition your approval to our county, which is a charter county, and they may preempt us for certain. Durham will. So.
Can we make a motion like that?
Yes.
It being
Yes, we can,
dependent?
yeah.
Absolutely.
So
It
I'd
would
like
be my suggestion to this
Yeah.
board, to
Good
protect the
suggestion.
city and the
Yeah.
board.
Yeah, I'd like to make a motion, we approve the application depending upon the application and approval of Durham, and if necessary, the Biscayne Shoreline Committee.
May I make a point of order on this?
Yeah.
I won't go into Durham or any of these other agencies until I go for an application for the expansion of it
Okay.
at this point.
Right.
Okay, but again, we're subordinate to
Of
that,
course,
so.
of course, we all are, trust
me.
Right,
I
so
know,
I
but-
just, thank you.
Okay.
Okay, well, I second. Oh, you want a
Okay,
second?
you
Go
s-
ahead.
It's fine with me, be my guest.
Second, a second.
Oh, there's a motion. Roll call.
Your roll call, please.
Ms. Cohen,
Yes.
Mr. McDermott,
Yes.
Ms. Boulay,
Yes.
Ms. Hill.
Yes.
121st Road is a very busy place tonight.
Yeah.
Yeah, we had the other happenings on
Thank you.
121st
Thanks very
Road.
much.
Mhm.
Busy little street.
Congratulations. Okay, this may be the best for last. This is V-7-15 Caesar Borgia. Special exception for use of proposed outdoor soccer facility, 1890 Northeast 146th Street. Not yet, not yet. Yes?
We have an issue with this item, Madam Chair, and that is, I have yet to see a power of attorney from Mr. Borja. My understanding is that he's not the property owner.
No, he's the applicant, and then he was waiting for the property owner to show up with the attorney with the.
Sir, did you receive the power of attorney? No. Sorry, he asked me.
Good evening. My name is Cesar Borgia. I live in 3131 Northeast 198th Street. I'm waiting for him. He sent me. He texted me and he said that if it will be possible, he has a complication. That if it will be possible, that can I read it? Just because I don't want to make a mistake. That it will be possible.
I'm going to object to anything being entered. I'm not sure if you've taken the oath, but I will object to the fact that you lack standing.
They what?
And that you lack legal standing to ask for a special exception on a property that you have no connection with, that you have no power of attorney, and I feel that you have absolutely no standing, but you could put your comment forward.
Okay.
But I am objecting right now on the record that you have no legal standing to proceed. Thank you.
Thank you. Again, I apologize myself because I'm here. It's been difficult to move forward with the landlord. He's a complicated person regarding he travels a lot and it's complicated. So I've been doing my best. He's supposed to be here. He just told me to, if I ask them if we will make a decision subject to submitting a POA. What I'm trying just to say, I understand the rules, and obviously I wouldn't take an oath if he didn't say, he takes me after the oath. Otherwise I won't be, wasting your time and mine. What I'm saying is, I'm here and I'm trying to comply with everything, and that's the reason I've been prepared, and I wasn't expecting that the lawyer, he won't appear in here. So.
I'm sorry, but he has absolutely no legal
Yeah.
standing. These
So
are
can we-
quasi-judicial proceedings, and although the rules of evidence are not strictly followed and pursued as if we were in a court, there is a requirement upon us.
Can we make a motion to table this?
Yes.
To the next meeting?
next
and
meeting.
you'll have your power of attorney, you'll have everything, and the owner of the property will be
We
here?
need a power of attorney.
Yeah, he offered me by the end of this week. I understand the rules. If it's not, it's not. I just want to clarify that I'm here because I was expecting them to be here. I understand the rules, and I'm trying to get anything. My question will be, when is the next
Next month.
Yeah, next month.
Next month.
next
Mhm.
month?
No,
I think it's every
it
2
would be
months.
July.
Oh, yeah, the month
Okay.
Would be
after
July.
next.
Well, it
July.
is what it
May I
is.
ask respectfully to give me a chance just to grant?
Mm,
Maybe
Sorry.
it's not possible.
It's a legality
Sir,
thing.
Does
the fact that we've allowed you to, stay here,
understand. Perfect.
It's not our fault. It's,
I understand.
We are required. You're not the property owner. You may be getting texts from somebody. I don't know who that person
I
is.
agree. I agree. And
I have to
believe it's
protect. This is my
frustrating for me
board,
as
and I
well.
have to protect this board.
I
And
understand.
And I'm sorry for, but without that document, we cannot proceed, and we have absolutely no jurisdiction in this matter.
Okay. Perfect.
And good
Sorry.
evening.
So
Thank
are we
you.
making a motion to table this, or?
you
I
need to
second
make
Yes,
a-
we could at least offer you, you have 2 months to come
make
up
a
with a
motion.
power of attorney, so.
Yes, I make a motion to table this item.
Thank you very much.
And I
I
second.
appreciate it, and I'm sorry again. No, I understand. That's the rules.
We're sorry.
Thank you.
We have a
I'm
second.
seconding, yeah.
Okay, so do we have any?
Everything,
Yeah. Roll
exactly, you're required to provide notice all over again. It's like you're starting all over again in July. So notice has to be, notice is required. I'm not, okay. So we have to start from scratch as if this never occurred tonight. Okay, thank you.
Sir, if I may, counsel, sir, if you are going to use a power of attorney, I would strongly suggest that you send a copy over for approval to the board's counsel, so that you don't arrive here and, so my suggestion would be you
Start again.
send him a power of attorney beforehand
I will.
for his approval.
My last question to Mr. LeBron was, did you receive a power of attorney? I gave you the very last moment in time to come up with that power of attorney, and at in fact, at the last proceedings, we ended up getting the power of attorney for the Audi dealership at 4:15,
Right.
but we got it in. But this
Yeah.
time around, we can't proceed. Thank
Okay,
you.
I understand.
So we have
Thank
a
you.
motion on the table, I
We
believe.
have to have a roll call.
Thank
Ms.
you.
Cohen,
Yes.
Mr. McDermott, Ms. Boulay,
Yes.
Ms. Hill.
Yes.
Are we ready
Sorry.
to adjourn? Do we do a motion, or what do we do now?
Any old business? New business? No? Having heard none?
No.
Thank you.
A motion to adjourn then. I
Ms.
second
Boulay,
it.
welcome. Ms.
Thank
Hill,
you.
welcome.
Thank you.
It only
looks
gets
like
better
we
from
have
here.
something coming in.
Thank you, Ms. Cohen. You
Thank
did
you. Thank you for
wonderful.
having us.
I'm wonderful, right?
Did great.
See, I fuddled.
Thank you.
I accidentally fuddled. I'm a great fuddler. Yes, it was fun.
Yeah.